From the 1st of October 2014, the right to attend antenatal appointments was extended so that expectant fathers and partners of pregnant women are now entitled to accompany their partner to an antenatal appointment. The employee or agency worker must have a qualifying relationship with a pregnant woman or her expected child in order to take such time off during their working hours. They do not need to have any qualifying period of service in relation to this right, meaning relevant employees are able to take such time off from the start of their employment. Agency workers must have been doing the same kind of job for the same hirer for at least 12 weeks in order to obtain the right to take the time off. The right to take time off is limited to no more than 2 occasions, lasting no more than 6.5 hours each, although employers, agencies and hirers are free to offer more time if they choose to. Similarly, employees are also entitled to use their annual leave to attend further antenatal appointments. Unless there is anything in the contract to the contrary, there is no express right for an employee to be paid for the time taken off to attend an appointment, so that any payment for the time off would be at the employer's discretion. In order to have a qualifying relationship with the pregnant woman or her expected child, the employee or agency worker must meet at least one of the following criteria. They are the pregnant woman's husband or civil partner. They live with the woman in an enduring family relationship and are not a relative of the woman. They are the expected child's father. They are one of the same-sex couple who is to be treated as the child's other parents. They are the potential applicant for a parental order in relation to a child who is expected to be born to a surrogate mother. In relation to the last 2 criteria, these are subject to further legislation, and employers and employees alike are advised to seek further legal action should such situations arise. An employer, agency or hirer may ask the relevant employee or agency worker to comply with certain formalities when applying for such time off. Should such a request be made, the employee or agency worker will not be entitled to take the time off unless they provide the employer with a declaration stating that they have a qualifying relationship with the pregnant woman or expected child, that the purpose of taking the time off is to accompany a pregnant woman to an antenatal appointment, that the appointment has been made on the advice of a registered doctor, registered midwife or nurse, and the date and time of the appointment. Employers, agencies and hirers may still refuse an employee time off where there is a reasonable to do so, although somewhat unhelpful. There is no guidance at present as to what would constitute a reasonable refusal. Employees who are unreasonably refused time off to accompany a pregnant woman are entitled to bring a tribunal claim within a 3-month time limit beginning with the day of the appointment in question, or where it was not reasonably practicable for the employee or agency worker to meet that deadline, within such a further period as the tribunal considers reasonable. If the employee is successful in such a claim, the compensation payable is twice the hourly rate for the period when the employee or agency worker would have been entitled to be absent had the employer granted the time off. Furthermore, should the principal reason for an employee's dismissal be that they took time off to accompany a woman to an antenatal appointment, such a dismissal is automatically unfair. Employees and agency workers are also protected from being subjected to any detriment for taking time off to accompany a pregnant woman to an antenatal appointment. For further information, please contact our employment team.